In this video we discuss about the Article 12 and 13 of Indian Constitution. Article 12 of Constitution of India Fundamental Rights. Definition: the state includes the Government and Parliament of India and the Government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the Government of India. Two legislative and executive organs of the state government, a state governments b state legislature, legislative assembly, legislative council of state. Three all local authorities a municipalities, municipal corporations, Nagar Palika, Nagar Panchayats b Panchayats, Zilla Panchayats, Mandal c Panchayats, Gram Panchayats improvement trusts, etc. 4 statutory and non-statutory authorities. A statutory authorities examples, National Human Rights Commission b non-statutory authorities examples Lokpal and Lokayuktas. Sanjay Bahal vs Union of India. The case dealt with the issue 81 the immunity enjoyed by United, UNO, and under the United Nations, Privileges and Immunities, Act, 1947. Delhi High Court, in May 2019, declared that UNO is not a state defined under Article 12 of the Indian Constitution. Sukhdev Singh v Bhagatram, the question before the court was whether ONGC, Oil and Natural Gas Corporation, LIC, Life Insurance Corporation of India, and IFC, International Finance Corporation, created by statutes would come under the purview of state under Article 12. The court, in this case, followed the test laid down by the court in the case of Rajasthan Electricity Board and held these. Article 13 of the Constitution. The 4 principles relating to fundamental rights. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of the 4 principles relating to fundamental rights. 13.2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 13.3. In this article, unless the context otherwise requires, law includes any ordinance, order, by-law, rule, regulation, notification, custom, or usages having in the territory of India the force of law. Laws in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. 13.4. Nothing in this article shall apply to any amendment of this Constitution made under Article 368 right of equality. The 4 principles relating to fundamental rights. 13.3. In this article, unless the context otherwise requires, law includes any ordinance, order, by-law, rule, regulation, notification, custom, or usages having in the territory of India the force of law. Laws in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. The 4 principles relating to fundamental rights. 13.4. Nothing in this article shall apply to any amendment of this Constitution made under Article 368 right of equality. Judicial review. As mentioned in Article 13, it is to be noted that judicial review as a norm has evolved over the years to uphold the principles of natural justice. The Supreme Court of India and the High Courts are vested with the power to rule on the constitutionality of both legislative and administrative actions. In most cases, the power of judicial review exercised to protect and enforce the fundamental rights. The Article 13 has expanded the scope of judicial review. The Indian judiciary is approached not just to ensure fairness in administrative action but also to rule on questions of legislative competence, mainly in the context of center-state relations. Case Keswananda Bharti v. State of Kerala 1973. The Supreme Court of India propounded the basic structure doctrine, according to which it said the legislation can amend the constitution but it cannot violate the basic structure. However, there is no definition of basic structure of the constitution.